Hello, chat. Yes, I was busy in Photoshop and busy working on trying to remediate the Clyde issue from earlier, so had to do a lot of work. KJ said, let's see the sweeping for Chille. Here's the deal. I've said this from the start where he got convicted. I think that was a bullshit conviction. You know, the First Amendment stuff aside, whether or not he qualified, whether or not he's First Amendment protection, I think it's bullshit what happened to him. I think it's 100% bullshit. Like it's not cool what happened to him. It's not cool what happened to him. You know, it was not fair. It was not right. And that's the way I look at it, chat. That's the way I look at it. He didn't deserve to be jailed like that. And when the officer's like, oh, I would have had him stand like 50 feet away. That's when the judge should have been like, what the fuck are you talking about? 50 feet away? No, we're not doing that. Like, ain't happening, Hoss. So, yeah, I think it should be addressed. I think that should have been enough to say, there's no way anybody would have thought that was reasonable. And, you know, he ended up doing jail time because he's a dick, but that doesn't mean he deserved to get that kind of jail time. I don't think that was fair to him. So like I said, you know, yes, when it comes to Chille, there are exceptions, but it's how it works, guys. We protect everybody. So is Chille not going to be arrested by the state of Ohio? No, because it's misdemeanor warrant. So it's basically like as long as he stays away from Ohio, yeah. Boogie's lying about his cancer, Lamau. Oh, that was great. Boogie got BTFO'd on LolCal Live. Yeah, Boogie, I mean, I'm going to do something about that because now Boogie's admitted to doing even more wire fraud. Like, Boogie's committed all kinds of wire fraud, probably mail fraud. You know, all the addition to securities issues, all the things he did with Fatty Coin. So, yeah, it's going to be great. It's going to be great. Yeah, but for 2 years, Boogie's a scumbag. Boogie lies, man. That's awful to lie to people about cancer for 2 years. So yeah, it's a very funny thing if you want to watch it. Eric Kush says Chille got himself into that situation. But did he really? What situation did he get into? Fucking hassling a cop who was being a little girl? That's not his fault. Why should he be in trouble? You know, oh, you picked on a cop who was a dick. Well, it's like, should have walked down that alley. At some point, it is the bad guy's problem. It is the bad guy's problem. Stratamalata or Stratamalata. Seahorse, I think, or a little dinosaur. I can't really tell. Looks like a little T-Rex with his like little short arms. Can't really see. Chille sweepings. Come on, guys. Come on now. Yes, I did see what got leaked on the farms today, which was very interesting. And I guess I'll bring it up now, and I'll have to bring it up later. Ooh, my pacer. Oh, yes. I didn't actually use it that much this quarter. I use court listener mainly. Yeah, apparently Minnesota, you can go access all this shit. You know, farms, like I'll own up to it when I'm wrong. So there you go. And also, guys, tonight we are going to I literally messed with everything I could to fix my pacer bill is $0 because we haven't had any federal stuff lately to look at. So with that said, we're gonna watch this tonight. We're gonna think we got StreamYard fixed. We'll see. Clyde thought his name was Chille. We need a Clyde proof of life. Hold on here. Chille the con artist saying, but he's still a fucking con man. Okay, that part's true. Chille is a con man. That doesn't mean he wasn't wrongfully arrested. That doesn't mean he's not wrongfully arrested. And hold on here. Clyde! Come here, buddy. Hey, up. Come on. There. Clyde's not in cuffs. Clyde's not in cuffs. There is no update for StreamYard. Funny, though. Yes. You want the body cam? I don't have the body cam. So, yes. There you go. All right. So, I give people a couple minutes to get in here. We're at 150 people. Let's get started, chat. Let's get started. This is not super long, which will help us. Just bring your own printer if you want to trifold. Bring your own printer. So, the courthouse is using 1.0 USB to upload. They've uploaded the floppies, chat. That's what happened. 3.5-inch floppies. So, Clyde, you went back down, buddy? Do you want to see 2.0? I know she just got back, so I'm going to let you go, Bubba. Oh, and I forgot to mention, we don't get paid for this, but I guess I'll pimp these for a minute. Nature Vet hemp treats. These are the dogs fucking love this shit. Just saying. So, the dogs love these things, and they're better than the poise treats. So there you go, Clyde. There you go, buddy. Do a hair follicle test on Clyde. Oh, God. He would light up the thing. Do those work? They work pretty good. I mean, depending on your dog, if your dog's got a problem, it takes a lot of them. And Sir Fitz says the body cam in real player format. You laugh about that? I'm sure J-Rock and then actually, who else we have here? Old Dog, Red, and a couple other people who are attorneys. For quite a while, like when I first started practicing, a lot of police departments had they had whatever company sold them the dash cams, came out with their own little fucking proprietary softwares and media players that were just absolute garbage. And you had to download like plugins and codecs and all kinds of bullshit just to watch like body cams and dash cams. Nowadays, like Axion and stuff like that, it's all like web-based, but even then, more things are now just like it'll play in like VLC or it'll play in media player. So you guys laugh, but that shit was a pain in the ass for a long time. That was a pain in the ass for quite a while. And I couldn't imagine how worse it was in like the early 2000s. So, 2.0 says they mellow Clyde we got to give him 3 times the amount. Yes. And yes, VLC player solves a lot of problems. It does. But there's also times where you get weird formats that it won't recognize. And I downloaded this thing called like NCH Prism. It's a formatter that'll reformat, and I reformat them into like VLC or something VLC will read, and it works pretty successfully. So, all right, here we go. Here we go, chat. Chille, and we are going to be using our Nevada judges. They do great. I mean, they do a phenomenal job at documenting things in the Nevada courts. Nevada. Handbrake is pretty good for re-encoding video too. I've heard that. Well, also we know about Handbrake from if you're making a Kyle Rittenhouse joke. NCH Prism is screenshotting to download 2 months from now. Okay. Hi, Kat. Hope you're doing well. So, anyways, here we go, chat. Here we go. The state of Nevada versus Chille Decastro. Now, this is weird that it's an appellate argument and it's being argued in front of one judge, but I guess that's how they do. Remember, every state's different. So here we go.
But the problem is, Mr. Decastro is supposed to know that he has to back up further. Decastro, do we have everyone we need on Decastro?
Yes, sir.
Is this Mr. Decastro?
It is in custody.
Okay, he is present. He's in custody. And the attorneys can state their appearances.
You are Christopher Orm on behalf of Mr. Decastro. Did you want to sit down?
No, you can stand up.
But you can sit down if you want. You don't have to stand up throughout the whole hearing.
Sit.
It's up to you. Might be a minute.
Alexander Chen on behalf of the state of Rhode
Well, the chief deputy district attorney.
Wow.
Wow,
May I proceed, Your Honor?
Absolutely.
that's impressive. Like
It seems
the
that
chief deputy district attorney. So this isn't just some rum. This isn't one of the random rum dums in the appellate group. This is actually like an important enough person. So we'll see. Let's see how this goes.
everybody agrees you have a right to film police officers. I'm not sure. I filed a lot of federal case laws suggesting you can film police officers, but the state doesn't seem to dispute that. In this case, you have a person who, for a living, this man for a living, that's his living, he films police officers. He has more than 500,000 subscribers. He is very, very famous as a First Amendment auditor. He's known as he testified around the United States and does this constantly. As I look at this case, there are multiple problems with it. It goes to trial, so let's start with what really happens. There's a letter written to the judge, and I cite to it, and you have a copy in the appendix. And the letter says this man's going to film the proceedings. So before the trial starts, the judge says, empty your pockets, suit pockets, all sorts of pockets, empty them. He says why, he complains it's a Fourth Amendment violation, you don't have a right to take my phone. And the judge also demands that defense counsel turn your phone off. And she said, I don't want to be part of the YouTube chat. And he said, we already are. This is the starting point to this trial. And the state says, well, the court has a right to, keep the court secure. Absolutely, you do. Absolutely. Have a right to determine who's filming. Absolutely. But what was interesting in the state's argument is they forgot to mention that the court never looked at the prosecutor and says, hey, turn your phone off. Make sure your phone is off. It's all directed at him and his attorney. You can't take cell phones. You can't do that. It's structural error to do that. And it also kind of shows that the court had an animus towards Mr. Decastro then.
I don't know that it's a structural error, but I think this is actually a very good argument to show that she had bias already. So I think that's actually not a bad argument to start out with. So Orem is making actually some pretty good arguments here. Like I said, I think this is, hold on here, guys. We need to mess with something here in the, sorry, we have to fixing closed captioning. So here we go.
Judge. He makes a statement to the marshal. It's unacceptable. It's unacceptable. It's clearly unacceptable. The judge was agitated by it. Understandably so. As I look at that, I'm like, I come in these courts all the time. You don't get to call a marshal what he gave. So I understand. That's a different matter. He's not on trial for calling the marshal a name, which he should have called. Maybe you could hold contempt proceedings for that. There are remedies that a court like yourself can do if somebody's being disruptive. Just because somebody's disruptive in a murder, calls your court staff a name, it's inappropriate. I would realize with a client or lawyer, this is not looking good, but that doesn't mean you're going to find or suggest that the person committed murder simply because he's acting or she's acting in a fashion in a courtroom that shouldn't have happened. But it was clear then that the trial was going the wrong way. So when we look at the facts of the case, that the police officer testifies that this auditor approaches, says that he's a member of the press, identifies him immediately as a member of the press. I have video here. I also have exhibits. And that he wouldn't back up. Now at trial, that was commented on by the officer a couple of times. He wouldn't back up. He wouldn't back up. The prosecutor argued it. Then they started on the 21-foot rule. It's an imaginary rule. We all know there's no such thing as a 21-foot rule. It doesn't exist. But nobody was stopping that. Not defense counsel was saying, where is this coming from? What rule are you coming to with this? And the prosecutors are well, he's violating 21-foot rule. There's no such thing as a 21-foot rule. And the state, to their credit, has abandoned and completely retreated from the 21-foot rule on this appeal. They don't argue.
Testify it was something he learned in the academy.
Yes. But I understand what it is, Judge, because I've used it myself in murder cases, and that is what they're taught and what I've argued that my clients are enduring is that if an assailant comes.
And excellent. I'm glad the state is backed away from the 21-foot rule. It's not a law. It's a rule of thumb. But even then, it's more like 30 feet. But remember, Officer Bork was like, no, I want him like 50 feet away. And remember, Rob, Law and Lumber, him and I were sitting there, guys. We broke out the charts for drawing on a. We broke up the charts for drawing on a, for drawing on the pavement. You know, we broke those out to figure out like what is the proper way to do that. And you know, we set those up. We sat up how big the parking spaces are, and we got to like 45, 50 feet away. Yeah, I mean, I think that's a very good. I'm glad the state has kind of conceded that point. Now it just sounds like it's really a First Amendment issue.
That an officer or a citizen within 21 feet, you won't be able to draw your weapon. That's what they're taught. So it's something that we use in a self-defense case. Oh, look, the guy was, coming, and so my guy had no choice but to shoot. I understand that's what police officers are taught, but that's got no bearing on this. There is no 21-foot rule, and in fact, we just go to Click. Click is a First Circuit case, both the state and myself rely upon. And in Click, I thought the language was so important to this case, because in Click, they begin speaking about that officers, in that case, person's filming on the Boston Common, filming from 10 feet away, 10 feet away. That's very relevant because the police officer in that case said, Mr. Decastro was 10 feet away. And so the First Circuit said that is 10 feet away. And then the First Circuit starts saying, police officers need to deal with provocative and challenging speech. They further identify that when a police officer comes in contact with somebody who's being rude or obnoxious, that they feel like they shouldn't be filmed, that they shouldn't have to endure that. And the First Circuit then goes on to talk about that officers sometimes retaliate because they don't like it. They don't like it. And they said that's what happened in Click. The officers didn't like it. You don't film us. You have no right to film us. Okay? And so when I look at the situation, I'm like, officers, we have a right to film officers. In fact, we have an actual statute on it. NRS 171.1233. This is cited in page 2 of my reply brief in footnote 1. Subsection 2, subsection A states, a peace officer shall not act to interfere with a person's recording of law enforcement activity, including, without limitation, by A, intentionally preventing or attempting to prevent a person from recording a law enforcement activity. You have a right to do it. We know it by statute. We know it by federal law. So what does Mr. Decastro do? When the officer tells him, back up, I can prove he does. I've attached the exhibits. I don't, if the state wants me to, I'll put it up and I'll show it. But we can see from Exhibit A that where Mr. Decastro is standing, he's standing in a particular parking space. We can see in Exhibit B, he has now moved back into the back parking space. I don't, when I say back parking space, I know that maybe not a good record, but he's moving away.
Right, it looks like it's in a parking lot.
Yes, it's a parking lot. He's moving from one parking space away. You can see it's away from the officer. So the state, to continuously argue he would not back up. Why are they doing that? Because they want to say he won't follow commands. And the accurate answer was, and I think the court would say, if you were asked to look at this case and say, what did Mr. Decastro do when he was told to back up? He backed up a short distance. That would be fair. Maybe the court would not like that language, say maybe it's a few feet. But he did back up. What is not fair is he would not back up. He would not comply. He did not back up. And then the officer was asked, did you tell him how far? No, because he was disrupted. So I couldn't tell him how far. The 21-foot rule. There is no 21-foot rule. Click said 10 feet is fine. And in Click, what's more interesting about it is the officers, what Click is deciding is not like this court deciding whether there's criminal activity. Click is suing the officers. And the officers are over in federal court saying, oh no, give us qualified immunity. And the federal court said, no, not for this. You're not getting, for arresting somebody who's filming. You're going to get sued. You're not getting qualified immunity. You're going to have to fight this and go to a jury. I think that's very relevant because that's what's going to happen with this officer. Undoubtedly, he's going to sue, and I think he's already started that process. I'm not a civil lawyer, so don't do that. But I know that that is what's taking place. So what is hindering this man from obstructing him from writing his ticket? He can just simply write the ticket. He can look at Mr. Decastro and think to myself, here's one of these auditors, walk over and write a ticket. He was asked the question, which I thought was really good at trial. He was asked, how did he obstruct you? How were you obstructed? And he said, well, I didn't know what his intentions were. I didn't know. Maybe he was armed. Well, that doesn't obstruct you. How does that obstruct you? That doesn't, he never gets in the way. So let's fast forward to Wilson. Okay? 3 weeks before this trial, the Court of Appeals considers one of my arguments here that the statute is unconstitutionally vague and ambiguous. The Wilson court determines that the only way that you impede is that you have fighting words or you physically do it. And the exact language of it is, we interpret 197.190 as applying only to physical conduct and fighting words. The court further explained that blocking the path of an officer may amount to obstruction. Well, we know that didn't happen. You can look at the video. There's no blocking. There's no blocking that goes on. And they also say that it could be non-aggressive, which made me curious. So I went and read the case. I thought, why could non-aggressive be? And it makes perfect sense. I would have never seen how non-aggressive could be obstruction. But what they then cite is they were pulling over an individual police car. And then the guy who I guess is armed then starts to run for police. Well, now they've got to chase it. So clearly you're hindering the police. So that made perfect sense. And that's the case they cited. What is interesting about Wilson is they also go on to say, as construed by this court, NRS 197.190 prohibits only physical conduct and fighting words that hinder, delay, or obstruct a public officer in the discharge of official duties or powers. As such, law enforcement has no discretion to arrest persons for protected speech or for physical conduct that is merely annoying and offensive. Judge, I have no doubt, I know you've watched this video, and I could see how anybody could look at this and hear the speech, get in your car, little doggy, and write your ticket, and find that to be annoying. I see that. But that's protected. And we've been told that's protected now by our courts in Nevada, by numerous federal courts. They went on to say the district court did not, so in Wilson was convicted, appealed, just like I'm doing here. And they point out in Wilson that on appeal, this court explained the district court did not have the benefit of our interpretation of 197.190 as being limited to physical conduct or fighting words, and it therefore did not consider whether there was sufficient evidence that Wilson engaged in physical conduct or other fighting words so as to support her conviction, and the case was remanded. Why I think that's important is because one of sort of the big picture that I want the court to see that I'm arguing, I think Judge Zimmerman was put in an absolutely terrible situation. Look at all this litigation we're doing here. This isn't new. I didn't come up with, oh, look, there's a new case that came out on a First Amendment issue. A lot of the cases I'm citing are, 20 years old, 15 years old. This is known law. If we have this issue before you on a case, isn't it incumbent upon me to file this pretrial?
I wonder why that didn't occur in this case.
And the state says something interesting, which I understand the state's advocating. The state says that trial counsel filed a memorandum. Well, it was comical. I understand what the state's doing. They're saying they need to try to protect their conviction. But the trial counsel, what he did is he filed some memo that right when the judge is making her decision, finding him guilty, she's like, what memo? He said, well, I filed them. She didn't read. And then the state correctly, the state said, strike it. It's late. So what trial counsel does is, at the last minute, can you imagine I'm coming in here talking about the facts and all of a sudden I'm like, oh, Judge, there's a First Amendment issue.
So it's not even we're making First Amendment issues, but I'd also argue at this point, he's made an ineffective assistance of counsel argument. And with that, that's a Strickland v. Washington test. Did the attorney's conduct fall below a certain threshold and below a certain standard? And yeah, you know what? Thinking about that, I do agree. I think he dropped the ball in spots. And had he not done those things, would there have been a reasonable chance the outcome would have been different? And I still agree. Had his attorney done it a little better and done it better, I think his attorney sucked. So yeah, I think that's fair, but I don't know. I still think we're harping on the First Amendment here, and I think this is an IAC claim at the end of the day.
Like, well, don't you think you should have briefed that and let me know? And I hear the state's argument, and the state says courts are presumed to know law. And I know you know law, but I also know, Judge, that we get into issues. You've been on the bench a long time, so I know you know the law. But let's say we're going to talk about a Miranda or Messiah issue, I think that it's incumbent upon us to give the material to the court. Let the state oppose it. Let us reply so the court can look at everything, have the court's clerk go maybe find research that interests you on this so that you can make an informed decision, as opposed to at the very last minute in a factual trial, like, oh, by the way, it was a Messiah issue. I don't understand why he did that. This was the issue. This should have happened beforehand. This should have been litigated beforehand. The court, like yourself, just like we're doing here, we should give you the opportunity to go look at it. And maybe my rendition of it is not the way you want to go. It's the state's rendition. But the fact of the matter is, at least you had it, and Judge Zimmerman didn't. And that's ineffective because he should have showed the court these issues. And if he had, just like here, the Wilson case would have come up. I know it was brand new. It was only 3 weeks before the trial. But then the court could say to the state, hey, you've got to have physical conduct or fighting words. We can't just do this on the driver's safety. Because at one point, the judge ruled, because the prosecutor kept arguing, and the police officer testified, well, the driver had a right to privacy. Like, the driver doesn't have.
Drivers out in public. I don't know if
Right.
the driver had a right to privacy. When you're out in public,
You don't have a right to it. And here's another thing, Judge. The state then comes back in their response. Mr. Chen always does an excellent job. And he is here as well. And he cites a bunch of cases, every single case. It made me realize when I read it that they have real legal problems. They've got problems with the law. Because what I did is I read every single one of their cases. And what I found was, oh, this is not at all what these things stand for. In other words, in fairness, they were saying their time, place, manner restrictions. Yes, true, the cases did stand for that. But let's start with Philadelphia, Fields versus City of Philadelphia. Now, when I first saw the video, what came to my, just jumped to my mind was I looked at it and thought, hey, wait a second. Didn't those people in George Floyd, weren't they filming it with cell phone? Now, I hadn't really followed it that much, but I kind of thought about it and it ran through my mind. So I then started pulling up the exhibits that I put, and I looked at it and I said, well, boy, those people are closer. They're closer than Mr. Decastro. Another thing that came to mind is, although I didn't really follow that trial very much, I did remember the firefighter. She's an off-duty firefighter, and she came to court with her uniform on. It was devastating for those officers because she said, I tried to tell them, and then they started saying, if you were a real firefighter, you'd know not to get involved. And she said she started using profanity at the officers. And she, at one point, is within a foot of the officers. There's an Asian officer in the back of the vehicle. She comes very close to him. When I look at that, I'm like, well, how is she not in the same situation as him? She's admitting she's using foul language. And I remember her trial testimony where she was crying, and I think it was extraordinarily impactful. I want to talk about something for a second, Judge. Police have to deal with difficult people. I know that because I witnessed it in your courtroom. Right there, right back there, right by the door. And I seem to remember, I was in a capital trial, came up from a break, about 1 in the afternoon. And what I see is Officer Hawks having to deal with, I don't know if she's a homeless lady or what, sort of small Caucasian lady, but out of control. And I'm watching, almost nobody's in here. And she's saying horrendous things to Officer Hawks. He there comes back up because I know there was a female officer, and they're trying to talk to her. Your marshal showed incredible restraint. I know that because I watched her try to kick him in the groin. She tried to kick him, and I watched it happen. And I don't think she was arrested. At some point, they did everything they could to just get her out of here. She was so obnoxious and abusive to your marshal. Yet the restraint shown was remarkable. Remember that? Because I addressed it with Officer Hawks. How did you do that? To me, it was amazing that a human being could practice that type of restraint. And that's what he did. And that's what this officer should have done. He was angry. When the state says to you, and when the officer said, I was concerned for officer safety. No, he wasn't. At the point when he says to him that annoying language that we call in the federal courts have said it provocative.
Mark, little doggy.
Get in your car, little doggy, and write a ticket. First of all, he's telling him to write the ticket. He's not instructing him. He's just, it's like a directive counsel, be quiet and sit down. Okay, that's a directive.
Hey, Jim.
But
Yeah,
not instructing him to
congrats.
be quiet and sit down. He's telling him to do it. And so I don't understand how the state can argue when I can see it for myself that the officer was concerned for officer safety. When he says that, when Mr. Decastro says it, you can see the officer just gets irritated beyond my God, you don't say that to me. He just comes at him. He doesn't pull a taser or anything like that. He's like, you're detained. And he grabs him pretty hard. And he's trying to say, well, I'm a member of the press. I'm a member of the press. You can't do this to me. He tells him, call your supervisor. Don't do this to me. And he's like, he brings out 2 cell phones. So, he's not armed. You know what he is. And even the officer said he knew about First Amendment auditors, but didn't say that they shoot people because he was asked that. He goes, I don't know if I said that. He was agitated. This wasn't about fear. This was about shoot people. You can see it's obvious. This officer was agitated. And the federal courts talk about that. They talk about a lot of these officers who don't want to be filmed. And I want to go back to City versus Philadelphia, or Fields versus City of Philadelphia, because in the state's answering brief, they question, why would you be bringing up Floyd? Are you bringing that up? And I realized the state saw, why are you bringing it up? I saw it was directly relevant to filming police. So since they cited Fields versus City of Philadelphia, I went and read it. And it starts off, so what that is that's an individual who's got concerns about unions, and they're filming in Philadelphia. And the court starts off with very, very, very interesting language. This is the Third Circuit. The Third Circuit begins their analysis This is the start of the decision. In 1991, George Holliday recorded video of Los Angeles Police Department officers beating Rodney King. They continue to go on about that. I cite that on page 4 of my reply. This case involves retaliation. Individuals making recordings have also faced retaliation by officers, such as arrests on false criminal charges and even violence. And that's because they're recognizing this. The federal courts around the United States are recognizing that police sometimes don't show the restraint that Officer Hawks does. You know, if you're being filmed and you got some irritating person, sometimes when we walk out of these courts, we got press that are like, what just happened? Did your client just get convicted? It's like, yes. Did your client just, they were sentenced to death? Yes. And you have to be calm. I can't just grab people and do it. You gotta suffer it. Suffer it. He didn't stop anything. He didn't grab the officer. He backed off from the officer. Yes, maybe annoying. Yes, maybe provocative, but it is not obstruction. It's not resisting. These are trumped up charges. And that's what the cases show. They can't show you a case. Not a single case could they rely on to show this is obstruction or resistance. Not once. And in fact, like I said, I think trial counsel should have presented it to the judge beforehand. Then the judge could make a correct decision without even a trial. I think if the court had seen it beforehand and not being so agitated by calling the marshal a name, that the court could have ruled that this is clearly protected First Amendment speech. Judge also, so I believe that I've argued that this is a First Amendment violation to convict him of it. It's also under the Wilson decision in the case, federal case law we've cited, it is clearly arbitrary and capricious. It's being applied incorrectly, and the court did not have the benefit of the Wilson decision because Wilson remanded it to tell the district court, you need to look at this. That did not happen here, and so that's a problem. I argued judicial bias. The state claimed that there was no objection. Again, trial counsel didn't object when phones started being taken, didn't make any kind of formal objection. But in Echeverria and in Gurry was my case, it's murder of an FBI agent, there was no objection. It was well before my time, but I do it on post-conviction. I held it on post-conviction. And it was that the trial judge had been, the FBI agent who'd been murdered, had actually investigated the trial judge. And so they found that that was an implicit bias, and so therefore there was reversal. The judge should have recused herself. She should have realized maybe I should hold this man in contempt proceeding, and send this to somebody else. She didn't do that. But I also think it was incumbent upon defense counsel to do a better job and inform her of that. And that leads into my last argument of ineffective assistance of counsel. And I know that on appeal it's rarely considered. However, I cited case law that it's clear as day, and I think the court can already see why wasn't this brief? Why is this whole hearing not happening prior to the trial date, so that Mr. Chen or whoever, it was Miss Agnes Alexis, why did she argue this against trial counsel and let the court make a decision? Judge, under the circumstances, reversal is mandated. It just, in every different area, I think under the Wilson decision, I think under the Click decision, I think on every single decision. And so I just want to make sure, Judge, that I cover all my points before I turn it over. And that is, they say Mr. Decastro was angry and hostile. No, this is what he does for a living. That's how he approaches them to see, can they handle it? I think in other videos, if the officer handles it well, like Officer Hawks, then he kind of calms down a bit. He did back up.
I'll object to that as facts that are not in evidence, speculation.
I'll withdraw that argument. And what other time, place, manner restriction? When to do this as an auditor, to do this.
Target parking lot, right?
Yeah, and broad daylight. When if it was a female officer, if it's a female officer on a lonely highway going up to Ely, and all of a sudden somebody's approaching at 3 a.m, I would think that's a different story. That shows officers like, God, what's happening here? And it's fearful. He does it in the most common way. He comes up, I'm a member of the press, annoying, provocative, all of those things. He's protected. It is one of the most, it is something that is sacred to what our system of justice is. And one of the decisions I cited said, this is the difference between us and a free society, where we can go up and be obnoxious to police. Hey, I see what you're doing. I remember from the time I was in law school, I couldn't cite the case, but I wonder if you remember, Mr. Chen remembers it, where somebody comes up to an officer and calls out a name, which I think is really, I remember as a law school, you shouldn't do that, that's bad, right? But the reality is I then learned from the Supreme Court, it may be bad, it may be obnoxious, if it's your child, you'd be like, what did you say? But it's protected, Judge, and he didn't do anything to violate or have those protections taken from him. I'd ask that you guys.
Mr. Chen?
Thank you, Your Honor. First, I'd like to thank Mr. Oram. Considering that our response was called comical, I appreciate the nice words from him today. Regarding first and foremost with the ineffective assistance of counsel claim, even if counsel could have done it, we're still focusing on the prejudice problem. Ultimately, we're here, and this is the appellate court for this matter, so this court's going to make a matter of law decision. So I think ultimately everything regarding that issue gets resolved on a prejudice problem, whether or not Judge Zimmerman was surprised at the information that he was put forth today. Now, with regard specifically to the First Amendment claim, Mr. Oram mentions that we cite to a number of cases, and the cases factually don't support our position, and I think we recognize that in our brief. There are cases where police officers have stopped individuals from filming encounters that they absolutely had a lawful right to do. This is why the court consistently talks about time, place, and manner restrictions. We don't doubt that that's the case, but to suggest that we didn't read those cases, I think is an unfair characterization, because what we're trying to focus on is whether the time, place, and manner restrictions were present in this case. Now, what I would argue, and what I think we argued in our brief, is cases like Glick are relevant to the extent that in that case, the individual clearly was not impeding, obstructing, or being a problem to police officers. The only thing that individual in Glick was doing was filming officers, and the officers were upset by it. That's a very different situation when we're talking about time, place, and manner in this case. Yes, it's in a public parking lot, but you have to realize that as the facts came out, that the officer was letting the individual film until he approached the driver. Now, I agree, privacy is not a thing necessarily in public, which is why we didn't argue it. However, there are other concerns for time, place, and manner regarding safety of everybody involved, including the fact that when the officer's writing a ticket, when the officer's communicating with this lady who's been pulled over, when that lady is sitting in her car and not free to move because she's subject of a traffic stop, that the scene needs to be secure. Now, I appreciate that the individual, Mr. Decastro, could have plenty of followers, and he might have followers. I didn't know of them before this date, and it doesn't appear that the officer did either. So ultimately, the officer is treating this individual as someone who's filming, but doesn't know what the ultimate motivations are. It could be to film, it could be to do something else, it could be to interfere with the driver, and I think that's what the evidence shows in this particular case. Not only did he approach the driver, the key part where the obstruction begins to occur is when the officer asks him to back away from the driver. He says, well, I'm a filmer. Great, you can film, but I need you to back up. And again, we're quibbling over how much the backup was, but I think
Clearly backed up.
he backed up a couple of feet. There's no question about that. But I think what the officer testified to was he wanted it a further distance based upon, in large part, how Mr. Decastro was operating. Now, if Mr. Decastro had backed up a number of feet and continued recording and wasn't saying and doing the things that he was doing, I think we'd have a very different situation. But the problem is
Mr. Decastro's supposed to know they have to back up further.
the officer instructed him in the video that to continue backing up. And rather than backing up further, he stood his ground and said, no, I'm relying upon a fictional 10 feet rule, which I don't think is a matter of law. I don't think the First Amendment says 10 feet is automatically permissible, because you can do a lot of things.
There are courts that have held 10 feet is sufficient.
Depending on what the situation is, all right?
I agree.
If I pull out a gun, is 10 feet still sufficient?
No, but
If
there
I,
was no
if
gun.
we're an open carry state, for instance, so there are individuals who can carry guns. So if we were to say automatically that I'm 10 feet away, and that as a matter of law, that's sufficient, I think it's very different if the individual is doing certain things. If the individual has a grenade in their hand, that's why it's time, place, and manner specific. We're not advocating, I didn't advocate for a 21-foot rule, even though that's what the officer said he was trained to do, in that he wanted the individual to move back a certain amount.
But he never vocalized that.
He
He
didn't.
never verbalized, said, hey, I want you to move 20, 21 feet back, go back to this line, don't come across this line. There was none of that, because it happened so fast. I mean, the officer testified it was within like 10 to 15 seconds.
Yeah, it's all on the video as well, Your Honor, so I agree that he doesn't give a specific number. And even if he had given a specific number, it's not that that specific number is somehow constitutionally permissible or not. But the point is, the manner in which this individual, who's unknown to the officer, is interacting with that officer in that very manner is what the issue is for us. And based upon that, the officer can't continue to feel that he can do his job, the traffic stop, speaking with the individual, of doing any records checks that need to be done, of writing the actual ticket, while this individual is yelling, refusing to move back at a further distance, and again, with unknown motivations. In hindsight, we can look at him and perhaps.
Yeah, you're not. Listen, he already knows he's in the The judge has been going after him, so I think he knows he's toast. But he's fighting. I'll give him credit. He's trying to make the arguments here. And honestly, guys, I didn't interrupt Orem there because he was just fucking laying it down. He's done a very concise argument about the ineffective assistance of counsel, and I do agree with it. Notice he said it and he touched on it and moved on. This judge is a Karen. Well, she's making some good decisions here, good comments.
Say, well, he was only here to put this on his YouTube channel. But ultimately, at the time that it's happening, this officer who interacts with him, who even tells him, you're allowed to film, but I need you to continue backing up. I think that's what the reasonableness is. That's what the time, place, and manner restriction is, not some magical number. As we point out in our brief, I think what Mr. Decastro believes and what counsel believes is that because Blake said 10 feet, that there's this line of 10 feet, and no matter what, I can do whatever I want within 10 feet. And I think even Wilson, although I understand it's remanded for further hearings, goes against that proposition that, oh, there's some type of magical number or anything like that. This individual in Wilson is yelling as there's a suicidal individual who is obviously a delicate situation.
But to say it's whatever the officer feels prudent is not helpful. I can't comply with that. There needs to be a bright line rule.
The police don't want this individual to hurt himself, and Wilson continues to yell and interfere with what's going on. Specifically in Wilson too, that even though they say physical conduct again is made up of multiple different things, including what we do with our bodies, but as well as what we're saying and how we're acting throughout the course of the interaction. And Wilson acknowledges that. In fact, they cite a treatise, what constitutes obstructing or resisting an officer. And if you look at that particular treatise, I mean, it goes on for multiple pages of various conduct that would entail obstructing. So here, it's not simply about the words. It's not simply about the fact that Mr. Decastro was annoying. It's not simply about the fact that Mr. Decastro was saying things like calling the officer doggy and whatnot. It's not about that. It's the totality of the circumstance which prohibited the officer from being able to safely and adequately conduct the traffic stop. And that's.
Well, he immediately released her.
He did.
Also, I mean, he gets out of the car. I mean, it appears to me he was going to release her regardless because it was so fast. He said, "You're free to go," and then he went to take care of the other issue.
Yeah, well, I mean, what we have in this particular one is he went and did the records check, and then he mentioned too she was surprised or even confused by the fact that she had an issue with her registration. Exactly. Now, again, I don't want it's speculating to assume what happened there, but certainly those are the facts that came out at trial. And so ultimately, whether he was going to take her or not, he may have taken her. Obviously, he pulled her over because the system, as he testified, said that there was an issue with her license. But because of the fact that this all went on, perhaps the obstructing was that he didn't feel comfortable to write. It wasn't worth writing this ticket. She already was informed of it so that he could deal with this other situation of this individual who was clearly obstructing with his ability to get to the very end of his investigation, whether he was going to release her or whether he was going to write the ticket. But the problem is the impediment is the individual who's continuing to yell and stand a number of
You
people.
can never do that then if all the officer had to do was say, because I had to go deal with this, I couldn't write the citation, right?
I think it's time, place, and manner specific though. In this particular case, when you watch the video, I think he is that much of a problem that this officer ended up, talking to him more.
So, but what's the obstruction? It's not the words and it's not the filming. I mean, the officer, to his credit, he said right away, you can film, you just need to back up, And I understand he didn't want him talking to the driver, but it didn't appear to me as though after he was instructed, don't talk to my driver, he didn't talk to her anymore. Is that accurate?
That is accurate, yes.
Right.
And I don't testify to that.
Right, and then he backed up. I mean, I understand the officer didn't think it was enough, and so, I mean, is it just that he didn't back up far enough for the officer? That was the obstruction?
He did back up far enough in addition to the manner in which he was acting. So had there been a conversation saying, officer, and again, everything is just fact specific, right? But the fact that Decastro is immediately yelling, arguing with the officer about the amount of backing up that needs to be done, that's what the issue is. It isn't about the space in itself or the distance in itself. It's a combination of factors of everything involved. Now, Mr. Orem says that depending on who the officer was, and where it was, and I believe where it was could play into it, but I think it's an unfair statement to assume that some officer, simply by virtue of being a female, would somehow be in an incredibly worse position, and that Mr. Decastro, for instance, could treat her differently or would need to treat her differently than the officer that we have involved here. I think
Well, if it was in Ely on the side of the road at 3 a.m. on that road between
for any
Reno
individual,
and Vegas,
for any individual, I would agree. For any
I
individual.
agree.
I'm just saying that it seems incredibly sexist to say that somehow a female officer would be unable to defend herself on that Ely road, but somehow a male officer would be automatically good to deal with the Decastros
We'll play the
of the
video
world
again.
who want to do an investigation. That's what I'm simply saying. That I at least wholeheartedly disagree with the characterization there in terms of the time, place, and manner. But I agree, an isolated road could be a factor, but they're all just factors. This case has its own facts. There will be other cases that come through the line, but I'm just arguing that pursuant to these particular facts, he was convicted of obstructing. And Mr. Orm doesn't address at all that second issue, which has to do with the resisting portion of things. Now, I think the case law is
that
clear.
Lisonby case. I mean, so even if, let's say, even if I agree that there, this was an obstruction, it was unlawful to detain him, that Lisonby case seems to indicate he still can't resist.
And that would be our argument. If he hasn't addressed it, I'm sure he will on his reply, but that's the last of my argument. Thank you.
And I'll address that. First of all, I didn't mean in any way, Judge, if you could take the biggest male officer, I meant, just giving the scenario, it could be 1 in the morning, 3 in the morning, female, male. I didn't mean it that way. I just meant the visual of how it's different there. What I just heard was sort of interesting. Mr. Chen just said, I didn't argue the 21-foot rule because it's not applicable. They sure did it trial, didn't they? That's what they argued. Even the prosecutor argued it. So Mr. Chen is only retreating from it because it's not a rule and it makes no sense. It's something used, as we talked about, in self-defense type issues.
Right, but if the officer would have said that, I'm not sure that would have been unreasonable.
I
really want you to be about 21
Yes.
feet back,
Yes.
give me some space, and,
Correct.
don't go past this white line. I mean, there were markers in the parking lot.
Right? And if he had grabbed his citation started and Mr. Decastro got, well, you're not going to do that. It's obstruction. This is an obstruction. And the 10 feet, I agree. Is it 10 if you're only 9.5 feet? Is it? No, I don't think that's the point. The point they're trying to make is that our statute tells us we can film police officers. It doesn't say 10 feet, 21 feet. It just says filming them. When he was told to back up, he did. And the state is now saying, yes, we all agree with that. We're quibbling over words. I'm only quibbling over words because they kept saying at trial he wouldn't back up, which is not quibbling with words. It's inaccurate.
That's true. I mean, the officer did testify in direct examination repeatedly that he didn't back up.
Yes,
But on cross indicated, well, he did back up. He just didn't back up.
substantial.
Yeah, he may have backed up inches. He didn't substantially back up.
Now, with regard to what are the intentions, I keep hearing, what are these intentions? He didn't know what the intentions are. And then that's why I put up, because I think there was testimony that I don't know who this guy is connected to. You don't know who this person is. Well, the officers employed didn't know who these people were. The people filming, they didn't know. They didn't know it was an off-duty firefighter. They probably had done something different if they knew who they were dealing with. But they didn't know. And so the same arguments could be made. Oh, they're within 10 feet, officer safety. Maybe those are all gang members and they're the same gang as George Floyd. It's his brother's, I won't be sexist. It's his sister who's going to pull out a gun, or some other person, male, female, going to pull out a gun and shoot. So we are doing this for officer safety. No, it isn't. And the courts, you can look at George Floyd and realize the courts in a big case in the United States, and these people have a right to do that. And the question I really ask, I think, is important. There was no abuse. The officer wasn't doing anything abusive to the driver. It's clear to say. Okay? But if he was, and he caught it on film, and now it's hitting CNN and Fox and all of this stuff, then they say, oh, yeah, we caught him, and 10 years from now, the Third Circuit's going to be quoting what he did. But he didn't catch them. So is that the standard? Can we film police officers? But if they're not doing anything wrong, and I'm using obnoxious language, then I can be arrested. Is that what the standard? It isn't, Judge. The
You're
application.
allowed to be annoying.
I'm sorry.
You're allowed to be annoying.
They're allowed to be annoying. They're allowed to say. I mean.
You're allowed to be obnoxious.
Yeah.
Mm-hmm.
And I realize we as lawyers appear in judges, in front of judges all the time. But we appear in front of juries. We're trying not to. You don't want to be obnoxious. It won't help your case. It won't help that. But I recognize this is some cornerstone. It's a foundation of our nation. The resisting. Did you notice the officer said, "Oh, when this resisting is happening, my body cam all of a sudden does go out." He testified he never resisted, and you can see it on him. He tells him, "Don't do it." The officer really grabs him hard. And then he's like, okay, I'm walking. You even see him with his camera. I'm walking back to your car. There's no resisting. He's trying to tell him, you're being unconstitutional. He does say, you can't do this to me. Call your supervisor. But they get him in handcuffs, and there he sits. By the way, the state didn't ask him to sit there. Agnes Lexis asked for a suspended sentence, and Judge Zimmerman decided to give him the maximum. He's been in there 4.5 months for this. And I kind of wonder.
So that characterization is, it's not a maximum. It's 3 months on each count consecutively.
Yeah, it's
Oh,
a
you're right.
maximum.
Okay, you're right. I stand corrected. For whatever reason, I guess misdemeanor 6 months, 6 months. Yeah, so she gives him, but the state didn't ask for that. They asked for concurrent 90 days suspended. It goes to show what really happened. There were so many different errors, and I can tell the court has a good handle of this. Judge, there is no resisting. It was an unconstitutional arrest. The man should receive the benefit. I mean, we have a beyond reasonable doubt standard. We can look at Wilson. I now hear the state really struggling. It almost sounds like me in a bad murder case where they're saying, well, what is physical conduct or contact? Because that's what Wilson said. And they're struggling with it because they don't even have, because there's no physical contact. Backing up and filming and then pulling out a second camera, it's not physical conduct. There's nothing physical. He doesn't do anything physical. The officer just lost control. And he was irritated. Maybe it's not.
Yeah, you can understand. I can understand.
Okay,
And
so
it kind of comes out of nowhere.
it's out of nowhere. It's, who wants to be called names? But that's what the courts are all saying. You've got to ensure this. Our citizens have a right to do this. And it also keeps our police, these auditors do help in some way because sometimes the approved police are doing, if there was an auditor on what he did, and that one was like, oh, he was saying these things. He wasn't. If I'm not a witness to it, no, he isn't. And the video shows that if somebody was filming it, he wasn't doing anything wrong. So some false allegation by some crazy lady, okay, it helps them sometimes. And also sometimes it catches bad police officers. Here, what we have is a situation where you have a right to do it. And so for those reasons, I ask that you grant the appeal and reverse this man's conviction.
Anything else from the state?
I would only briefly say that in the Floyd case, no one was
Why is it stopped?
arrested. That's what the distinction is there.
That's a very good. I thought it was a very good rebuttal arguments there. Very good rebuttal arguments. Very good rebuttal arguments.
So people were allowed to film the encounter, and obviously other things happened from that Facebook. The issue is not that they were filming, that no one was arrested there. And the case law makes it clear in Lisenby and other ones, if there's a probability of substantial harm or death, then individuals can actually interfere and it wouldn't be obstructing. So the case law, I just want to point out that distinction, but otherwise I have nothing else.
Okay, so this time the court's gonna grant the appeal and reverse the convictions based on its First Amendment protected conduct. And Mr. Orm, you can prepare the order.
Yes, ma'am. Thank you very much, Madam.
He needs to be released from custody, so.
He'll be released.
We'll-
Hey.
Thank you.
Thank you.
So I mean, there you go, guys. I mean, I actually think Chille's got sincere joy on his face. He won. The conviction's reversed. It's overturned. He's getting released. He got released today. So Chille won. They're saying that it was an improper conviction. He should be released immediately. He won his freedom. So Chille's done. He wins. Now, what does this do for Chille? Well, Young says that's a shame. Chille's behavior is protected. I mean, let's go back to what actually he did, because let's start. Let's take a look at what he did. This is only 5 minutes, but this is the 5 minutes that matters. Here we go.
You good? Why'd they say that you were pulled over?
Before you release.
Oh, I see.
Like, what a
Oh, I see. Oh, gotcha.
You can film, but you need to stay away from my driver. Back up. Back up, or I'm going to detain you.
You're going to detain me how? In which way?
Obstructing. Get away from my car.
Actually, I'm standing right here. I'm at least 10 feet away, officer. I got to tell you, I'm a constitutional law scholar. You can do whatever you want.
Now, okay, all this is fucking jibber-jabbering nonsense. God told him to back up. He backed up.
Just understand something. Your name will go on the lawsuit. Mind your own fucking business. Mind your own business. I'm a member of the press. Go get in your car and do your job, little doggy. Go feed her.
You're being detained right now.
Okay, then detain me. Oh, she's free. Oh, you're going to detain a journalist?
Yes.
2015, Rodriguez.
Over my car.
Ah, don't.
Now, if we go back just a hair,
You're going to detain a journalist?
Yes.
2015, Rodriguez.
Over my car.
Don't.
The cop wanted Chille over by the semi truck, which is about 50 feet away, directly behind him, which is fucking nonsense. It was a little too quick by him. I think so. And he told him being a little doggy, and the guy got his butt hurt. And Young, the cop didn't have to say, get back or I'll detain you. Well, there's got to be a little bit of like, get away. You're interfering with this. But was he interfering? And then Chille said something that pissed him off. So, yeah, this is, Chille's behavior is protected, but that allows you to go do whatever the hell you want, Young. That allows me to go do whatever I want. Allows me to call a police a fascist cocksucker. Look, because here's what he did. Here's what he did. Here's his conduct.
Oh, gotcha.
You can film me. You need to stay away from my driver. Back up. Back up. I'm going to detain you.
You're going to detain me how? In which way?
Obstructing. Get away from my car.
Actually, I'm standing right here. I'm at least 10 feet away, officer. I got to tell you, I'm a constitutional law scholar. You can do whatever you want, but just understand something. Your name will go on the lawsuit. Mind your own fucking business. Mind your own business. I'm a member of the press. Go get in your car and do your job, little doggy. Go feed her.
You're being detained.
See, as soon as Chille says that, cop's like, man, you're under arrest now. Well, sounds like he had a tampon attack. That's not how it should work. It's what it looks like. The officer didn't keep his cool. So, Chille's behavior wasn't really that insane, was it? When you look at it in hindsight, it's like, I was pretty timid. I was pretty timid. Chille's a mastermind manipulator. That's fine. If he's smart enough to bait the cops and tiptoe lines, well, then the cops will learn how to do better. That's how this works. If he knows the rules better than them, oh well, the government will start writing checks. Oh well. Oh well. They'll learn to leave him the fuck alone then. Yeah, he rolled up on a traffic stop. Okay, so? I don't care if he, traffic stops get shooty at times. You know what? If they're those guys go work on a fucking crab boat if they're worried about, you want to talk about injuries and dangerous, go work on a crab boat, go do logging. Police work's fairly mundane as far as the risks they suffer. It's not even in the top 10 of dangerous professions in America. Michelle says, I love he spent several months in jail for running his mouth. Yeah, but you know what? At the end of the day, the cop fucked up and it was wrong. So he was wrongfully jailed. He was wrongfully arrested. And the trial court and his attorney in the trial kind of fucked him. So, is it not really fun? It's kind of awkward. Luke says, I never stream on Rumble anymore. Rumble gives me so many problems. I'll start trying to do it again. Bella says, Sean, you're only giving the Castro's camera. The cop was not just casually talking to a speeder. I understand that. Fine, he's standing there. And as soon as Chille says, go fuck yourself, little doggy, he gets mad. That's not how that works. It's okay, write your fucking ticket. Because all this would be FOIA-able. He would get the FOIA of the stop. He could get a FOIA of the traffic incident. So it's not like there's really privacy there. They're pointing out there is no privacy. It's in public. So. Bella says, I don't care as long as he can stick it to a cop over a criminal. Not true at all. Not true at all. Not true at all. Hell, you watch me on body cam night. We laugh at people doing retarded shit all the time. He antagonized the cop soon. Not yet soon. Well, yeah, sure. Sure. He's antagonizing him. That's what Chille does. That's what he does. No, now here's the thing. People are saying, well, does Chille have a civil lawsuit? He's got, I mean, he can sue under 1983, but is he really going to get anything out of that? Probably not, if I'm guessing. I mean, that's the. I mean, it's not like he completely violated his constitutional rights in a way that the Court of Appeals in the Ninth Circuit is going to find repugnant. So I think Chille loses his 1983 claim. Although I can see the city settling. I can see the city cutting him like $5 or $10 grand and telling him to go fuck off. I mean, paying off, nuisance money. Chille's a master. I mean, yes, Chille's going to become very, very insufferable at this point. Cat says, are we stream sniping tonight? Nope. I mean, I'm not rewatching what I already saw. Like dog shit opening arguments is not something I really want to watch again. Not at all. Bella says he was in the middle of an arrest. I mean, he was in the middle of doing a traffic stop. And some tweaker asshole rolls up and starts to pick a fight. Cop didn't even know who he was, sure. But the guy's got a camera. And at some point, you have to figure out what the hell's going on. Does Chille win any money? I don't think so. I mean, maybe a little bit, but not. He's not like getting 100,000 out of it. Yeah, they'll probably be entitled to qualified immunity at the end of the day. Like I said, I don't think it's going to be considered that drastic what the police did. Chille Decastro says 5 to 10K. That's it. Yeah, they're going to cut him a little bit of money. Hope he goes away. Let's yeah, like insurance companies. Here's a couple of bucks. Go fuck off. Do we talk about Boogie 2988 getting career ended? Well, we'll see if he's got to get career ended. Darcy brings up a great point. He's got another case coming up, and that's the case with the police officers on the motorcycles, where he's walking around the tape and starts fighting with them. That one, I actually think he's toast. So, like, oh, Sean doesn't like the police. Like, no, I think the police were justified on that one. Chille fucking cashed a check. Chille wrote a check and the police cashed it. So, no, I think Chille is actually toast in that regard. I think he's 100% toast. I don't know where that one is. I'm trying to find the link for it. Let me see if there's. Let me see. You're looking here on things. Chille's thing. Yeah, guys, I don't see it. Yeah, I don't see Chille's second stop where he gets arrested, basically for the same things. Except that time, yeah, I think he probably isn't going to win there. Young says, if I antagonize the cop in the middle of a traffic stop, I expect to be arrested. All right, well, here, let's run this hypothetical, Young. Young, where are you going? Fuck you. I'm not saying anything. Well, I just want to know. Where are you going? Go fuck yourself. I'm not talking to you, piglet. I mean, at what point are you antagonizing him? Get back in your car and write me a ticket, you cocksucker. I mean, have you antagonized him? You made him mad, you hurt his feelings. That's like, how does that work? How does that work? I mean, we say that, but what does antagonizing mean there? One of the cases Orange cites is a case of qualified immunity. Yeah, but I think in this one, he'll probably get qualified immunity. Where's the obstruction case at? It's somewhere. It's the one where he fucks with the bike cops in the middle of the night. The motorcycle police. Maybe I can argue for time served in that case for this case. He'll probably get something like that. Yes, I did. I sent in a super chat. I was hoping Boogie would answer that. Like, how does it feel to commit wire fraud, Boogie? But he didn't answer. Master Blaster said he crossed the tape. Yeah, he crossed the tape and then he got into like a real fucking pissing match with the cops. Like that what I think they probably are justified in arresting him. You expect Chille to start filing lawsuits. He already filed them. Those lawsuits were already pending. So, but no, I do agree. Like when you look at it in hindsight, the judge saying, well, everybody take out your phones. Chille, you have to surrender your phones. I mean, you're arguing a prior restraint at that point. I think he didn't necessarily say that, but I'd almost make that argument there. I do think that there was ineffective assistance of counsel. I think Chille's attorney didn't do a good job, but I think a lot of that was Chille thought he was going to represent himself. So the guy wasn't ready. Are we going to stream snipe Chille's live stream after jail? Yeah, we'll see what happens. Young says, keep playing the tape. You want to see the rest of Chille's tape? All right, we'll do the rest of Chille's tape. See if I back up and find it. Actually, hold on here. Hold on, Chad. I gotta actually grab it. So give me 1 second here. The hell was it? I mean, here we go. Here is the rest of Chille's arrest. We'll keep playing the tape here.
You're being detained right now.
Okay, then
So he just told him to go get in his car, little doggy, and he says you're being detained.
we'll go on the lawsuit. Mind your own fucking business. Mind your own business. I'm a member of the press. Go get in your car and do your job, little doggy. Go feed her.
You're being detained right now.
Okay, then detain me.
Yeah, you're free.
Oh, she's free. Oh, you're gonna detain a journalist?
Yes.
2015, Rodriguez.
Come over my car.
Don't put your hands on me.
Come over.
Don't touch me. Don't put your fucking hands on me. No, you're not. I gotta make sure. Hey guys, make sure you guys get my people.
It's not obstruction. If he had no grounds to arrest you, if the actual grounds of obstruction are not legal, Chille's allowed to resist. You know, I mean, I'd make the argument you're allowed to resist unlawful arrest. So, and this judge overturned everything. So,
The phone.
and to be fair here, Chille really didn't resist them, but whatever.
This is so you ended the stop, you dunce cap. Did you just end the stop? So that's
Yes.
a 2015.
Come over here to my car.
No.
Come over here.
No.
You need additional unit.
Bring your supervisor, please. Bring your supervisor, please. Don't touch
over
me.
to the car.
You don't get to put your hands on me. Don't grab me. Don't grab me. This you're not. First get your supervisor out here. You're not just gonna grab me and throw me on the ground. You've already released the. You've already released her. This is 2015, Rodriguez.
And Chille's wrong. This is not Rodriguez v. United States. He's completely fucking wrong on that point.
Versus United States. I'll walk right in front of your car. Let's go. Sure, come on. Come on. Come on.
You need to set the phone
There you
down.
go.
on
No,
the hood.
no. I'm a constitutional law scholar. You can't take away
Set
my
the
phone.
phone down on
I'm
the
in
hood.
fr- I'm now in
You're
fr-
being detained.
Please,
Now you're going to put hands on me.
No,
Come over here.
Why are you grabbing me?
Come over here.
Sure.
Come over here.
Let the phone roll.
I don't care about the phone.
Why are you grabbing
Turn
me?
around.
I'm a
Turn
member
around.
of the press.
Turn around.
I'm not doing anything.
You're being detained.
I'm not
right now.
doing
Turn
anything.
around.
Keep your phone.
Stop.
So it ends there, and that's the whole tape. So, yeah, I mean, like I said, Chille's a dick, but I don't think he did anything there. Chille wants you to click on his video. I'm sure he does, but I think it's fair. It should be discussed. It should be discussed. Do you think Chille can construct a cogent legal argument to overcome qualified immunity? No. Chille's going to need attorneys to help him. Chille can't do it on his own. That's part of his problem. Master Blaster said he was told to cross the tape and then he did. Yeah, but he wasn't in trouble for crossing the tape. The cops were like, okay, cool, have a good one. And then Chille started acting like a fucking idiot. So he actually didn't get in trouble for being inside the tape. They had understood that he was crossing through. The judge was biased to the defense. I mean, that are we going to say that's a bad thing? A pro-defense judge? Remember, guys, who's entitled to a fair trial in America? There's only one side, and it ends with offendant, and begins with duh. Has Chille ever suffered an old school hood beat down from the cops? No. Misanthropic Anthropoid is saying, so is Chille like Turtle Boy? There was a crossover. There was a Chille Turtle Boy. You say that. Oh God, like I said, there's lore. There's all kinds, it's neat. I am a lore master. I know some of the lore. I was there when it was written, which when Chille was dealing with the mass hole troll mafia. Kate Peters, you also know her as Krusty Panties, as Turtle Boy calls her. She was A-logging the fuck out of Chille about 2 years ago. She was A-logging the fuck out of Chille. Then there's a guy, Michael, I forget what he's called. He runs a channel called Blue Bacon. He was a former military police officer. He's a private detective now. And he kind of like mocked Chille a lot and critiqued him. There was also, he did a lot of Jeremy DeWitt stuff too, Blue Bacon did. And so Blue Bacon kind of A-logged him, but in a wholesome way. But Kate Peters A-logged the fuck out of Chille. And Chille deserved it. Chille came to Boston and started fucking around and called Kate out. Kate fucking cornered, like, at a Memorial Day parade. And Chille acted like a little bitch in front of her. At that point, Turtle Boy and Kate weren't on good terms. They're still not on good terms. But Turtle Boy kind of allied with Chille, and they tried to fuck around with her as far as like a couple of protection orders and some other nonsense. So Chille and Turtle Boy have a history. Their paths like crossed for a nice little bit of time. They were swimming in the same river outside of Boston. So it's funny you say that. If you knew that, that's a very good way to get a call back in. If you didn't know that, that is hilarious. It came up that way. Has anyone seen the meme of Chille as the Black Power Ranger? Yes. Yes, they're funny. Resist with force. I mean, even then, if you're getting unlawfully arrested, I argue you have the right to resist that arrest. I mean, the biggest thing was it was such bullshit that the judge is like, fuck this, we're done. Darcy says street justice finds its way to guys like Chille. Oh, sure, certainly it will. I mean, Chille almost got killed. Chille was in LA fucking around in the street, and some, homeboy came up to him, and Chille's talking shit, and the guy you can see him grab his shirt, and Chille kind of gets scared and fucking runs. It's hilarious. Chille runs away like a little bitch. Luke is saying, I don't know. It's cringe to put your own self in that situation. I agree. But you know what? You're allowed to do that. We let people go fucking skydiving. I mean, it is what it is. J-Rock says, please don't sweep for him. I mean, I'm not sweeping, man. It's just the truth. God, how do you say this? Cifralag says he's the next Eugene Volk. You guys don't know who Eugene Volk is? He runs a thing and part of Reason magazine called the Volk Conspiracy. And Eugene Volk is a super, like, uber libertarian conservative dude. He is like, he graduated from like UCLA as a computer dude at like the age of 16, went to law school. The dude's like fucking like super, 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 super retarded smart. And he's got a lot of like law professors and right in it's called the Volk Conspiracy is what he called his thing for a long time. It's really fucking good if you ever get the chance to look it up. It's got a lot of it's got all kinds of shit in there, and you're just like, yeah, I don't understand half this, but it's really good. It's really deep stuff out there. Can you show the motorcycle cop arrest? I don't have the link for that one. I can't find it. Catherine says, please give notice if you snipe his show. I'm not going to snipe it. There's no need to. J-Rock says, actually, Sean, we all know if you were this cop, you would have tased and peppered him. No, I probably would have just been like, fuck it. I'm not dealing with this. I'd tell her to go, and I'd fucking hop in my car and drive off. I'd be a lazy fucking cop. I wouldn't be writing tickets. I'd write the bare minimum. The extended Chille verse, yes. I streamed from his monastery on the Kiwi Farms. Yes. Yes, and Turtle Boy and Chille. Yes, and Lauren De Laguna. Lauren De Laguna actually contacted Chille and started interviewing him and did a couple of interviews of him when she was getting ready to take the Arizona bar or whatever it was. And yeah, that's how I learned about Lauren De Laguna, was like, oh, she fucks around with Chille, in the sense of like, not like that, but she thinks Chille's somebody to listen to. And I'm like, oh shit. Like, not really. So that's why when I see people like Lauren De Laguna on, I'm like, what the fuck? Completely caught me off guard. What's A-logging? A-logging is when you're out there just dogging people really hard on the internet, and you're picking at them and prodding at them for every little thing. Like, if you ever watch Kino Casino admits they're A-logs. Okay? You know, or as Ethan Ralph would say, them goddamn A-logs. Oh, yes. It's trolling and mocking at the highest levels. Yes. Mingo says, wait, Krusty Panties likes Chille? No, she doesn't like Chille. She liked A-logging the shit out of him. So she thought Chille was an asshole and an idiot. So she was mocking him and fucking with him for a long time. And Chille was fucking with her and mocking her back. And they were just going at it on the internet. What is Turtle Boy? Turtle Boy is the guy in the Karen Reed case who kind of blew it all up and broke it open. If you use the code Kate Peters is, it's Kate Peter, not Kate Peters. Sean will repeatedly call you to yap at you for hours about the lore. Yes. Imagine Chille getting pulled over by Brian Albert or Brian Higgins. That would be hilarious. I have streams on Chille. Yes, I have 2 videos I did on Chille, including a live stream where Chille was doing like an impromptu. He did like an emergency constitutional law session, and I had Jeff on and I had Kurt on, and Kurt, I think, was about to have a stroke as how stupid Chille was. Oh, it's already 12:30. We got to wrap this up, chat. Blue Bacon's lawsuit, yes, blew out a positive point of Chille in jail. Yeah, but Chille's lawsuit, like, that's the thing. Chille is not a litigator. Chille can't litigate for shit. He's been cited by SCOTUS before. Who? Who are you talking about? Orem? Or I don't know who you're talking about. Eric July Freedom, yes. Blade says, am I enjoying Baldwin so far? No, and the problem is, we're in the part of the case where it's like, it's all the same shit from Hannah Reed. So it's kind of like, I've already seen all this. Yeah, there's a bunch of boxes, and Sith Kinney had all kinds of ammo laying around. Like, let's get to the Alec Baldwin part. I want to get to the part where it's a little, like, the more unique things for him. So I don't mind it. It's an interesting trial watching Alec Baldwin sit there like, you know, like this, like, you know, you're being accused of killing someone unlawfully, and you're just back here like, well, I don't give a, hey jury, this is me, not giving a fuck. Like that's not the way you want to sell yourself to the jury. Abel says, how's the gym face off the Ricada going? Well, I don't know how Nick's doing, but I'm doing okay. We're getting a lot of walking in. So the casino always wins. Yes, the house always wins. Feezer is a prime example of A-logging gone right. Yeah. Sleazy says, still trying to fix Texas and Louisiana. The shit's foobar, take some shekels. Oh, are you down there doing work, man? Well, have fun. Be careful down there. Chille's a fraud. I don't disagree. Chille overall is a fraud and a scam artist, and he takes advantage of people. I don't disagree with any of that. He's got a real sketchy past. But this time he was right. Surprised he hasn't sued me yet. Well, Chille doesn't fuck with people who know who can fuck him back. Chille picks fights with the people he thinks he can push around. Chille said, I can pinpoint the date Chille started buying subs. Yeah, I mean, yes, all out of nowhere, his sub count's like kind of creeping up and then just whoosh like a rocket, like in a 15 to an unrestricted climb. Brittany says Kurt was turning purple over that stream. Yeah. So, Eugene Volk has been cited by SCOTUS. Yes, 100%. 100%. J-Rock says redirect us to Kino. Well, I mean, they don't stream on here. I can't redirect to Kick. So, Dershowitz has a video out that Baldwin's innocent of the charges. I mean, there's a bit of an issue there. There's a bit of an issue there. I think he points, pointing like, you're going to have to convince a jury that it was okay for him to go willy-nilly with a loaded gun like that. And it's okay pointing guns at people. Like, it's not going to work. Luke is saying it's interesting, but it gives everyone brainworms. Even Runkle lies about this case for money. I don't know what you're talking about. Like, what's Runkle saying about the whole thing? Yes, if you guys want to go see Kino Casino, it's over at kick.com. Duncan Idaho says Kurt is usually purple, though. I mean, I don't think so. Let me see here, making sure I didn't miss anything. So he says, I'm off, be easy. Luke says, stop dodging me, causing drama in your chat, fat man. No, I just addressed it. So tell me, what the fuck are you talking about? Answer me. Answer the question, Luke. Redirect us to the Baldo body cam footage. I don't know when that's happening, so I can't help you. Johan Naxos been a member for 1 month. Thank you, Johan, is saying, you going to read this membership milestone, Sean? Yes, I am. Sean Strickland challenged David Goggins. Oh, that David Goggins is old. He'll get his ass beat. Luke is saying, Runkle says the intervening cause is shit because Baldwin, and the same for Hannah, but okay, Runkle says the intervening cause is shit because Baldwin was the but-for cause. What? So is Runkle saying Baldwin is guilty or not guilty? I know you're probably trying to, like, brevity's the soul of wit here, but I can't. Tell me how the fuck you pronounce your name. It's saying Chille could actually be a JP. No requirement in Nevada that you mean a justice of the peace? Be a lawyer in rural areas. Interesting. Goggins would die in the ring. He would. He'd have to be carried out of there. I'm pretty sure that Runkle thinks Baldwin's guilty of something. I do too. I 100% do. I mean, he's got to, like, I've thought about it more and more and more as we've gone through this over the, months, and, him pointing the guns and doing all that shit. Yeah, that there is some issue there. And I mean, for a while, I didn't think he did, but the more I've looked at it and the more I've sat through it, I've been convinced, this is not going to be good for him. Oh, that Runkle won't be charged? Well, he is charged. I know as a UFC follower, yeah, it's human cockfighting. Do I follow off-road races like the Class 11 Stock Beetle? No. I like watching all kinds of racing, though, if it's out there. There's very little out there that to do. J-Rex says, when are we getting Clyde branded switchies? At some point. Sullivan says, I miss Pride FC. It was a million times better than UFC. Yes, it was. C141GG says, if you hire a mechanic and they tell you your car is safe, then the steering wheel falls off. I don't get what you're saying, but also, how do you pronounce your name? I need to know. The state has to prove the intervening cause was reasonably foreseeable. Runkle hides that when confronted about it. Okay. We got to talk. Talk to me in Discord, because I am. Just say C3. Okay. Talk to me in locals, because I'm trying to keep up with you, but it's been a long day. So, yeah. Chille Connor says, you're keeping me here, honey. Sorry, I just left dirty, filthy bugs. Oh. Human cockfighting for John McCain. Yeah, well, fuck John McCain. Was Baldwin hopped up on something? He very well could have been, but jeez. They need to work on his dosage, because tonight wasn't a good night. Today wasn't a good day. Oh, yes. You don't know anything about guns, so you hire an expert who's supposed to be an expert. Yeah. It was literally her job to keep people safe. Yes. But, C3, you don't go around walking up to people and going, click. You don't do that. You don't point guns at people. It's dangerous. Why? Because it could be loaded. In the First World Firearms, all guns are always loaded, so you verify. Well, if you never verifies, guess what? Bang, it's loaded. Baldwin got an stash. Yes, but for Alec Baldwin, there wouldn't be a homicide. Yes, that's very true. So, all right, guys. Yeah, so Chille's out, and I'm sure he's going to gloat, and I'm sure he's, the thing is with somebody like him, he's now going to think he's invincible and probably fuck up even worse. So, I mean, if you don't like Chille, have some hope. He's probably going to step all over his dick very hard in the near future. And that is really it, guys. I think it should have been overturned, and good thing it got overturned. Sadly, it took 4 months, though. So that was the bad part. Oh, well. So, guys, tomorrow morning, 10:30, we will get Eric Bauran day 2, and hopefully this gets going because, oh my God, it's been a drag and just makes me just want to a little bit. We're retrying the Hannah Reid case, and I can't do it. I can't do it. Also, StreamYard makes me want to do that too. But look, StreamYard didn't shit out. We went like 40 minutes with no problem. So fingers crossed, it's fixed. So that's it, everybody. Take care. Yeah, hold on. They should realize some rules for gun safety somewhere in writing. Yes, they should. They should. All right, guys. So that is it tonight, chat. And take care, everybody. And I will see you tomorrow. And remember, just because Chille did it doesn't mean he's guilty. Doesn't mean he's guilty. Congrats, Chille. Don't piss this away, which I think you're probably going to do.
Weapons blacksmithing and models of planes, esoteric works and even some trains. Much merriment had while drinking White Claws, tips on hunting and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the